Good afternoon, everyone, and thank you for attending this afternoon's 3PB Barristers Public and Regulatory Law Group webinar, which is an update on practice and procedure, focusing on the new practice directions to Part 54 of the Civil Procedure Rules, which came into force yesterday on Bank Holiday Monday. We will also be looking at the current situation with the government's proposals for changes to the law on judicial review following the independent review of administrative law, which reported earlier this year. I will begin with introductions to this afternoon's speakers in a minute or so to give all participants the opportunity to log in to the Zoom webinar session. My name is Mathew Gullick, and I am the head of the Administrative and Public Law team at 3PB Barristers. I've been practicing regularly in the Administrative Court for about 15 years now, principally in London, though I've also appeared in the Administrative Court in both Manchester and Birmingham, doing a wide range of public law work. Of particular interest to me today will be the changes to procedure brought about by new practice directions, which are part of a visible trend towards what has been described as greater procedural rigour in the Administrative Court. And certainly when I started practicing in this area of the law about 15 years ago now, the approach of many practitioners seemed to be that in the Administrative Court, certain aspects of the Civil Procedure Rules were to be more honoured in the breach than in the observance. The view of the senior judiciary, expressed most recently by the Lord Chief Justice in the case of Dolan and Secretary of State for Health in December last year, shows that if there was any such culture in the past, it's certainly not one that is in place any longer, because the Lord Chief Justice said this at paragraph 117 of the judgment in Dolan: procedural rigour is important not for its own sake, it is important in order for justice to be done. It's important that there must be fairness to all concerned, including the wider public as well as the parties. It's important that everyone should know where they stand, so that, for example, the defendant can properly prepare evidence in a timely fashion. So with that brief introduction to the broad topic of this afternoon's session, can I turn to our three speakers? Caroline Stone was called to the bar in 2005. She's a member of the London B panel of junior counsels at the Crown in civil cases, and has particular expertise in both education law and national security litigation, covering terrorism and related immigration, asylum and citizenship matters. She is the assistant editor of National Security Law, Procedure and Practice, published by Oxford University Press earlier this year. Prior to coming to the bar, Caroline worked for the Public Law Project, and whilst in practice, she's also worked for several international tribunals, including the Appeals Chamber of the Special Court for Sierra Leone, dealing with war crimes and crimes against humanity. Mathew Wyard was called to the bar in 2014. His practice includes a wide range of public law matters, court of protection work, community care and education law, in which he has particular expertise, being described in the Legal 500 as one of the very few barristers in the country who has a true grasp of Welsh education law. And that's a direct quote. He is a member of the Regional C panel of junior counsel to the Crown, and has been published in a range of journals, including the Times Higher Education, and is a contributor to leading textbooks on the law relating to children and education law. Alistair Covley was also called to the bar in 2014 and practices principally in education and discrimination law, doing work for a wide range of claimants and public bodies. Her recent work includes the independent inquiry into child sexual abuse, acting as counsel for Ofsted, one of the core participants in many of the inquiry's investigations. Alice contributed the education law chapter to the current edition of Patterson and Kareem on judicial review, published by LexisNexis in 2019, and she's ranked in both Chambers and Partners and the Legal 500 for education law, the latter categorising her as a rising star. In a minute, I will be handing over to Caroline Stone, who will be talking about the new Practice Direction 54A. Then Mathew Wyard will address the new guidance on electronic bundles and Practice Direction 54B on interim relief. And finally, Alistair Covley will look at Practice Direction 54C on venue, as well as the government's proposals for changes to the law on judicial review. We won't be dealing today with something the eagle-eyed amongst you might have spotted, Practice Direction 54D, which, just so you're aware of it, concerns categorisation and hearing timetables for cases proceeding in the planning court, and so is specific to that very specialist area of practice. We will aim to finish at 4 o'clock as scheduled, and there should be sufficient time to deal with questions at the end of the session. Please could you post any questions that you would like to have answered into the Q&A box on your screen. You'll see at the bottom of your screen the Q&A option. So please click on that option to submit questions, not in the chat window, please. The PowerPoint slides and links to useful information and guidance will be emailed to you after the event is over. So can I now invite, please, Caroline Stone to begin this webinar with her talk on Practice Direction 54A. Caroline.
Hi, good afternoon, everyone. Well, I passed the first test. I managed to share my slides with you and unmute myself. So it's nice to metaphorically see you all. And thank you very much for joining us. There's nothing like bringing you down to earth after a sunny bank holiday, quite as much as looking at some reforms to the civil procedure rules. But here we are, and thank you very much for joining us. As Matthew says, I am going to take you through part 54A, which is entitled Judicial Review. So quite a lot to get through, a bit of an unenviable task. The slides are fairly comprehensive, and so to that end, I won't stop and linger in view of the amount we have to cover today. I won't linger too long on the matters which are obvious. What I will say is that the slides encapsulate the changes, of which there have been quite a few to this practice direction, and should be read alongside the practice direction itself. So let's jump straight in. At the outset, just to say, you'll notice very quickly that there are some recurring themes to the changes. Some of the changes are quite a fundamental shift, as they were intended to be, as Matt made reference to the case of Dolan. Others probably will strike you very much as common sense and things that hopefully we're all doing as a matter of best practice. Alternatively, if they sound familiar, it's because they are things that were incorporated previously in the Administrative Court Judicial Review Guide. But the feeling, not just in Dolan, but in cases prior to that, was that, as Matthew says, the rules were very much being observed in their breach, and that there was a need for this to be codified. The other point to stress at this stage is a theme that will become quite apparent from the slides. The words succinct, concise, and clear appear many times in the course of Part 54A. And the intention over all of these reforms is to achieve fairness and clarity in the way judicial reviews are conducted, that appropriate amounts of costs are spent on the right aspects of a case, and that all parties know where they stand as early as possible so they can engage with the litigation in the most effective manner. If you could see the attendance list today, it bears out that judicial review is a very broad church, and so the stresses and strains and dynamics of a case involving a central government department, for example, will be quite different for those involving, for example, an exclusion from a school of a pupil. So whether these reforms in fact achieve the fairness and the clarity that they are designed to achieve, I think will be discovered in the course of time, when it's seen how they actually work in practice. The question of electronic filing will be dealt with by my colleague Matthew, but it will become apparent that that is a recurring theme as well. And I think overall the sense is that what these reforms in total amount to is a need for very active case management by the legal team involved in a piece of litigation. Sometimes that is more or less difficult, but I think the overarching theme is that there won't be perhaps the accommodations that the Administrative Court have previously made for cases to become clearer as they go along. The idea is you really have to hit your target at the beginning as best possible, and if things shift or change, you need to make sure all parties are aware of that. So that's the overarching themes, and now to dive in. The claim form and the statement of facts and grounds, this relates to Rule 54.6. They're quite a good blueprint, really, for the other provisions in this practice direction. And they really are a combination of what I said before in terms of codification of best practice and requirements that have been set out elsewhere. So I'll take you through those in slightly more detail and then skip through or counter through the following slides to get to the slightly more interesting or controversial bits, I should say, shortly. So before seeking permission to apply for judicial review, the claimant must make proper and necessary inquiries to ensure, so far as reasonably possible, that all relevant facts are known. Well, I mean, to those who have any experience of judicial review and are aware of the pre-action protocol, that isn't really saying anything that we don't know. The claim form itself must set out all the material facts, which are, according to the practice direction, those that are relevant to the claim. One might think that is a bit tautological and doesn't really actually tell you what the material facts are. That doesn't necessarily help you narrow those down. Any statutory provision which excludes the jurisdiction of the court, so any ouster clauses, any reference to alternative appeal mechanisms that should have been used prior to seeking judicial review, are things that must be set out in your case up front in the claim form. Again, really a matter of good practice. In terms of the contents of the claim form must be accompanied as previously by a statement of facts and grounds. What's happened here is that the rules have now become quite prescriptive as to what that must include and what that statement of facts and grounds, depending on whether you choose to include them in separate documents or one document, what they must look like. So here's our first encounter of the words clear and concise. They must be a clear and concise statement of the facts relied on and the grounds for bringing the claim. As concise as possible. If you haven't got that in paragraph 4.2 brackets 1, then you'll pick it up in 4.2 brackets 2. And they must not, unless the court have granted permission, exceed 40 pages. And it's said in the practice direction that the expectation is that in many cases, the statement of facts and grounds will be significantly shorter. So here's the first point at which we hit the fact that judicial review, as I said before, is a broad church. So to some people, I can imagine hearing that you can only have 40 pages for your claim form might be causing you now to recoil with horror. And to others, you might be thinking 40 pages, yeah, sort of 10, 14, and we can say everything that we need to in terms of crystallizing the core points of the case, both factually and legally. Of course, judicial reviews, I do a lot of central government work, and there, with good reason, sometimes pleadings need to exceed 40 pages, particularly where they're multi-party cases with both claimants, multi-party claimants and defendants. And so to that extent, those in charge of litigation just really have to nail this one down early in terms of making applications to the court if there's going to be a need to ask for an extension. To the relevant page limit. Statement of grounds must identify in separate numbered paragraphs. One might think we're being taught a little to suck eggs there, but bearing in mind that the administrative court also will receive a lot of claims from litigants in person, this is really setting out clearly that the court needs to have things presented in a digestible format. And the matters that are set out on the slide in terms of the other things that need to be included in the statement of grounds, I think are pretty obvious. And just in case you weren't clear, the statement of grounds should succinctly explain the claimant's case by reference to the statement of facts. In terms of time limits and directions for the claim, just to pause on this slide for a moment, the rules are a little ambiguous in this regard, but I think, don't quote me, but I think a fair interpretation of them is that any application to extend time is something that can be included in a document separate from your statement of facts and grounds. Likewise, any directions wouldn't really have mattered previously because page count wasn't an issue. And indeed, in anything I've ever drafted, I always make reference to time limits in the grounds themselves. But I think in view of the page limitation and the way that the practice direction has been set out, the court are allowing parties to supply a separate document that covers those points if necessary. Nothing particularly novel in what can be included in the bundle. The main thing which Mathew Wyard is going to talk about is the fact that going forward, depending on how you feel about it, the genie or the monster is not going to be put back in the bottle, and electronic bundles are going to be the way forward, at the moment in parallel with hard copy. But I think there's a clear indication that this grasp for modernity, the court's not going back. So you must bear that in mind, because in my experience, in the short term, it can often front load the work that's required in order to prepare an adequate electronic bundle. Moving on to the acknowledgement of service, as I said, in the interest of time, I won't linger on these slides, but it's essentially the same headline points. There's a page limit, that's on the next slide, which is 30 pages. I'll come to that in a minute. But again, one must identify the relevant facts and the legal basis of any defence in relation to the judicial review. What I'll say in terms of the page limit is that it's often a tactical decision for defendants as to whether they really go hard at the summary grounds of resistance. If you can knock a case out, sometimes it's worth expending the money at that point, even though the costs you can recover for an acknowledgement of service are relatively limited. I am not sure that this page limit really gives much indication of what the court are expecting in that regard. And indeed, the detailed grounds, which we'll come on to momentarily, you get 40 pages for. So it's actually not, it's perhaps an invitation to plead your case at least as well as you need to in terms of summary grounds of resistance. Renewed applications for permission. This is a novel provision of the practice direction. I think it's one that encapsulates, again, best practice in the sense that if you are going to certainly advise clients, often that's the question that's asked, is there any point in renewing? Obviously, if a case has been certified as totally without merit, then the answer would be no. But in terms of the ordinary refusal, you would ordinarily, in order to advise your client, be addressing the reasons that the judge has given when refusing on matters on the papers. And we all have had hearings where in person it's possible to convey the complexity of the case more readily, and therefore it's worth a renewed application. But here, this is setting out in this bit of the practice direction that you must address the reasons that the judge has given. And importantly, identify which of the grounds that you are going to continue to rely on. I've underlined the 30 minutes there because it doesn't strike me as very long, given that it includes judgment. Again, going back to the point I made about active case management, this is where solicitors will be and counsel will need to be alert and alive to the need to request a longer hearing if necessary. Interestingly, the court has to be informed of an agreed time estimate within 7 days of the application for renewal being filed, which is somewhat interesting, given that the defendant, that the practice direction quite clearly states that there's no need for a defendant to attend a renewal hearing. Moving on to the response, I got rather excited there, drum roll please. The detailed grounds have to be as concise as possible. No surprises there, and cannot exceed 40 pages. The first bullet point on this slide sets out a clarification of Rule 54.14, which deals with the response, in that if you as a defendant feel that you've set everything out that you need to in your summary grounds of resistance, rather than file detailed grounds of resistance, you can inform the court that you are going to rely on what you've already filed as your detailed grounds of resistance. One thing I will say is that interestingly, there's nothing in the practice direction allowing for a formal reply by claimants, which, as many will be aware, is something that is done and is appropriate on occasions, whether by way of pleadings by way of response or further evidence to be served in reply. The administrative court are issuing, in many cases, standard directions that in judicial reviews, once permission has been granted, which will make provision for some form of reply, and for that to be an application made as early as possible. So again, trying to really encourage tight case management of proceedings and ensuring that all parties know where they stand as early as possible. I think it's interesting that the rules haven't formally incorporated that. It tends to suggest that the court don't want to make this proceeding any more complicated than necessary or invite it to be any longer than necessary. So there you go. One thing I will say is that in the case of Dolan, which Matt cited, that the court said as often as not, excessively long documents serve to conceal rather than illuminate the essence of the case being advanced. And they make the task of the court more difficult rather than easier, and are wasteful of costs. So I think it's important, whilst it might be easy to jest about the page limits, to understand the reasoning behind it. In terms of evidence, paragraph 10.1 of the practice direction makes reference to the duty of candour and the fact that the defendant should, in its detailed grounds of resistance or evidence, identify any relevant facts and the reasoning underlying a measure which is the subject of the judicial review. Just to pause on that and say that the duty of candour is obviously broader than simply identifying facts. It may involve actually producing documents, it may involve producing policy-related material rather than what one might think of traditionally as facts. So this is obviously a practice direction that is intended to be a guide to the rules. It is not intended to establish new law itself. And so I don't think anyone should read any I'm sure you've spent all bank holiday trying to work out what the finer points of this practice direction mean, but I don't think one should read anything nefarious into this provision. In terms of an application for oral evidence or cross-examination, it must be made promptly, again, a recurring theme, and it must be made in accordance with the requirements of Part 23. So where previously things may sometimes have been done a little bit fluidly by way of letter to the court and what have you, another recurring theme, as you'll see when you have a chance to look at the slides in slower time, is that Part 23 applications are writ large throughout. Additional grounds of claim. This, again, you see the theme of promptness, which is a change. Before, it was notice had to be served on the parties no later than 7 days before the hearing. And I think one of the things underlying this slide is perhaps what was referenced in Dolan about the nature of rolling judicial reviews, which everyone watching will be familiar with, where a judicial review is bought and then either the facts on the ground change, new policy is issued, new guidance is issued, or perhaps even a fresh decision is made. And what the courts were saying in Dolan is one needs to be slightly wary of trying to shoehorn that all into the same judicial review. It may not always be appropriate. And so these provisions here about the additional grounds of claim, I think, are designed to make sure that situation is avoided, as well as just making sure that everyone is clear of where they stand. A quick word on interveners before I get to the final topics of skeleton arguments and documents for the hearing. In terms of interveners, I think this is a pretty fundamental change to the way things are going to be done going forward. I mean, the term intervener isn't used. The term is that the court has the power to hear any person. Judicial review claims often raise matters of significant public importance, or indeed may be brought against one government department, but in fact bring others into scope. If it relates to a human rights matter, then there will obviously be the various notification requirements in relation to a direct declaration of incompatibility that have to be followed. So it's not uncommon for there to be interveners. Interveners often, or I should say sometimes, are in the form of public interest groups such as Liberty and Amnesty, where you have matters of, as I said before, public importance involved. The intention, I think, behind the rules is that there should be visibility of interveners as early as possible. And to that extent, a Part 23 application has to be made. There's no longer just by way of letter to the administrative court. there is a stronger presumption that the hearing, if a hearing date will be jeopardised, the intervention will not be granted. So previously it was said in the rules that applications to intervene must be made at the earliest reasonable opportunity, since it will usually be essential not to delay the hearing, which is somewhat weaker than the provision I have put on the slide for you here. But I think where the crunch point comes, and where perhaps there are access to justice issues, are in relation to these requirements here, which is that in the actual application to intervene, if a party wishes to make representations, they have to give a summary of those representations. And if they wish to provide evidence to the court, then that also, a copy of that evidence has to be provided, which is a significant front loading of the process for interveners. I think the suggestion will probably be made that this should encourage early dialogue between the potential intervener and the parties, but perhaps is not entirely realistic in terms of how cases unfold and the point at which parties may be aware that an intervention would be of assistance to the court and necessary. But that is something that the parties will, a potential intervener, I should say, will need to pay close attention to. Skeleton arguments then, and documents before I hand over to my colleagues. So skeleton arguments, 25 pages is, unless permission is granted, is the standard going forward. I'm not going to linger on them in terms of what the detail of what they contain, save to say that I think that probably there are two implications of this page limit, particularly when you notice there that they can't include extensive quotations from other documents or authorities, and that they have to be self-contained. So in other words, there's no sort of copying and pasting of your grounds or your acknowledgement of service, summary grounds of resistance into your skeleton argument. I think the implications of that are twofold. One, it may be that parties end up seeking longer hearings, because where you had the certainty of knowing that everything was in a written document for the judge to ponder, even if you didn't get to it in the hearing, now one will not have that luxury. But I think the other thing is to go back to the theme I mentioned earlier, which is that to the extent that sometimes litigation it's sort of one gains clarity as you go along, there's a need often for expedition and what have you. That means it's not necessarily possible to get the fullest of instructions as you would like at the outset. And where it may previously have been possible to use skeleton arguments to perhaps shore up certain aspects of the case, if that hadn't already happened, that possibility will no longer be there. So again, the essence of this provision is that the court don't want, so we're told, they don't want a sort of copy of the judgment that they're supposed to write. They just want the pithy, by this point in proceedings, why should you win and why should the other side lose? And just to say that costs won't be allowed necessarily if you fail to meet those requirements in terms of skeleton arguments. So the last point from me then, in terms of the documents to be filed prior to the substantive hearing, this is also a pretty significant change. So no later than 7 days before the hearing, the parties need to file an agreed list of issues, an agreed chronology, and an agreed list of essential documents. The existence of those documents in a hearing won't necessarily be a surprise, but the fact that they need to be agreed and the work that might involve and how realistic or otherwise this provision is, I think will be tested over the coming months. And the other novel aspect in terms of documents is that there is now a need for a core bundle. If the proceedings, if the hearing bundle is going to exceed 400 pages, and Matt will take you sort of through further guidance in terms of the electronic requirements. I won't go through them now, but do have a look at the listing policy in terms of timescales and applications to adjourn and vacate the hearing. No significant changes in terms of the agreed final order, save to say that be aware that both the draft order and the agreed statement of facts need to be signed. And finally, for those who practice in immigration and asylum cases, not a significant amount of amendments, but I leave those two there for you. And I will pass over now from one Mathew to another Mathew.
Thank you very much, Caroline, for that very clear exposition of the changes, some particularly far-reaching ones in terms of practice for in terms of preparation for hearings there. So now Mathew Wyard is going to look at the new guidance on electronic bundles and practice direction 54B, and I'll hand over now to Mathew.
Well, thank you, Matthew. One matter before we start, if you're wondering why you've got an enormous face on your screen, it's because my headphones have decided to stop working, so I'm having to sit a bit closer than usual to my laptop in order that you can hear me, but hopefully that won't be too much of an issue. I'll share my screen. And as Caroline and Matthew have said, I'm going to start with the electronic bundles guidance. This was guidance that was published by the Admin Court Office on the 27th of May, so last Thursday. So it's very current, very new. The first point to note is that any electronic bundle produced must be suitable with Adobe Acrobat Reader, PDF Expert for MacBooks, and PDF Exchange Editor. One point to note, I suppose, if you're a solicitor, is that this means that you're likely to need to purchase new software if you don't already have it. One PDF file only must be filed for your bundle. So long gone are the days where you can send multiple PDF files over. You now have to send one single bundle. The guidance deals firstly with urgent bundles for urgent cases and bundles for non-urgent cases. So where you're seeking urgent consideration, your electronic bundle mustn't exceed 20 megabytes and should be filed by email. When you're filing a bundle for a non-urgent application, it can exceed 20 megabytes, but you should have a 20 megabyte core bundle that includes as a minimum the documents I've set out on the screen, and in addition to that, a supplementary bundle containing everything else. And where it's non-urgent, bundles must be filed using the document upload center that I'm sure you're all familiar with. Now, if you thought that what Caroline was talking about earlier in terms of claim forms and pleadings was prescriptive, wait until you get a load of the guidance. It must be paginated electronically or otherwise typed, and it must start, the pagination must start on page 1 of the PDF file, i.e. the first page of the bundle index, to ensure that when you're typing your numbers into the PDF search bar, the numbers on the PDF document matches up to the PDF file itself. The index must be hyperlinked, and electronic and hard copy bundles pagination must be exactly the same. Now, depending on the PDF software you're using, what you will often be able to get is a link on the left-hand side of the page where you can see effectively an electronic index. You have to now do that, that's mandatory, so you have to have your hyperlinked index at the start and each document at the left-hand side of the page marked also. And this is where things get slightly confusing if you're not so tech savvy. All bundles must be text-based, not a scan of a hard copy. In effect, it means that the PDF documents must be original PDF documents, i.e. not ones you've put through your scanner. However, if you do have no choice and you have to scan things, then you need to undertake OCR, optical character recognition of the file. In effect, OCR means that your PDF file becomes searchable. Any document in landscape format must be rotated so it can be read from left to right, and the default display view must be 100%, i.e. so that the documents you're looking at on the screen look like they would in real life. Resolution, which if you're like me, you don't quite fully comprehend, should be between 200 to 300 dpi to ensure that when everyone's scrolling through the bundle, there are no delays. But what about that awkward situation where you've got a vast quantity of additional documents to be added to the bundle? Well, what the court guide tells us is that inquiry should be made with the judge about how they would like them added to the bundle. And if there's no direction, then you should make a separate file with the appropriate sub-numbering. Failure to comply means that your bundle may not be considered by the judge. Now, that was a rundown of the electronic bundle guidance. Fairly comprehensive, fairly dull stuff. We'll be providing you with a link to the slides and the guide after the talk, so you can have a look in more detail there. But now on to more interesting topics. Practice Direction 54B for urgent applications and other applications for interim relief. This is interesting because, as far as I'm aware, it's the first time that there has been a practice direction purely for urgent and interim applications. As you've heard Matthew and Caroline talk about earlier, there is at the moment a cultural shift through the admin court looking at compliance, and we can see this certainly when you look through the case law of the recent DVP and the Secretary of State for the Home Department Authority. This was an immigration case where an application for urgent consideration had been made, but Mr. Justice Swift looked at the claim and identified significant concerns about the conduct of the claims. And the 3 points were, in effect, that the claim had been filed as an abuse of process because it wasn't urgent. The claimants had failed to provide the required information within the N264, N463, and that the claimants had potentially breached the duty of candour. Now, the three obvious points coming off DVP, and we can see these throughout Practice Direction 54B, is firstly that moving forward, there is going to be stricter enforcement around when urgency and expedition should be used, i.e. make sure that if you've issued a claim urgently, it is actually urgent. Matthew or Caroline would correct me if I'm wrong, the urgency is only justified when there's potentially an irreversible prejudice to the claimant unless interim relief or expedition is granted. So you need to be realistic and think about whether or not the claim that you're proposing to bring is actually urgent in the sense of what the work of the admin court deals with. If following that and make sure you follow the procedure, thoroughing your duty of candour to the court. So, what does Practice Direction 54B actually say? Well, firstly, on the form, all information required by the form must be provided. In particular, why the application needs to be considered urgently, why the request wasn't made sooner, and the timescales for consideration. Now, when I say all information required by the form must be provided, it needs to be provided on the face of the form itself. If you look back at the DVP judgment I mentioned earlier at paragraph 16, in that case, the claimant solicitors had done what, to be fair, is done quite commonly. They'd written, please see the attached grounds of judicial review, and filed them alongside the N463. No, said the court, that's not acceptable. You need to state on the face of your form why the claim is urgent. So that's the first significant change in my view. You no longer can you just say, please see the attached grounds. You need to actually deal with the point on the form itself. In terms of bundles, you need to file a hard copy and an electronic bundle, as I've just gone through, in compliance with the electronic bundle guide, and it must contain at the very least your form N63, all the pre-action correspondence, and all communication with the defendant concerning the urgent application. The reason being that, as I understand it, the court is getting fairly frustrated with urgent claims being issued without the defendant and any potential interested party being given a proper opportunity to consider the claim prior to issue. In terms of orders, no surprise here really. All applications must be accompanied by a draft order setting out the interim relief requested or the expedited timescales, whichever is relevant in your case. Interestingly, actually, before I move on, one question that cropped up in a talk on this I went to recently was whether or not the hard copy bundle and the electronic copy bundle had to be filed at the same time. The obvious reason being that the electronic copy bundle can generally be filed much quicker than a hard copy bundle, particularly if you're not able to go and drop it off at the court office. The response, which came from a member of the judiciary, was that they are not expecting hard copy bundles to be filed at the same time as electronic copies. Whether that will be put into practice and reality, who knows, but at the very least it's a helpful indication. Where you've got an urgent application for interim relief, we've got a continuation of Caroline's theme from earlier. Any application must be set out clearly and concisely. And I mentioned the duty of candour earlier, and this is the first time we see it within the practice direction at paragraphs 2.2 and 2.3, that the applicant prior to filing will be expected to have taken reasonable steps to investigate matters material to the application. Now, you may think prudent solicitor would do this. I suspect that as this has now appeared in the practice direction, the court may not have shared that view. The application itself must be supported by evidence and witness statement that must cover all matters that it's reasonable to assume a court would consider material to the application. And importantly, and harking back to the duty of candour, that must include matters supporting and those matters undermining the application. Again, continuing the theme, applications for expedition must include a clear and concise explanation of the reasons why expedition is necessary. And in terms of candour, the application itself must include a statement of the position of the defendant and any interested party on the expedition application sought. Or if you can't get that, then you have to explain the steps that have been taken to contact the defendant and interested party to ascertain that position. And if you remember what I mentioned earlier, in terms of the documentation you have to file with the court, you'll have to be filing your evidence to show the steps that you've taken to contact the defendant and interested party. So you need to make sure that you do it. So what top tips can we give you in terms of practice direction 54B? Well, I've got 5. Firstly, only use the process for really urgent claims. If there is a way around using it, then try to do so. One method that's been discussed fairly recently is making the application within the claim form itself and then chasing the court. If the admin court office is still like it once was, then you may be chasing it for quite a long time, but really keep that pressure on. Secondly, keep an open dialogue with the defendant. Don't put unnecessarily short deadlines on responding to give positions on expedition. In reality, I think it's likely that the admin court will take a fairly short shrift approach if you as a claimant are putting in and notifying a defendant a couple of hours before you're intending to issue the claim. I would suggest that at a minimum 24 hours is likely to be appropriate, although I accept that there are likely to be exceptional cases where you can't do that. In any event, present your case in a fair, even-handed and in a trustworthy way, i.e. a way that will really get the court's trust and faith in your being reasonable. Where you're seeking expedition, the court's going to want to hear from all parties if it can, so try to build that into the timetable before you make your application. And finally, make sure that the interim relief you're seeking, if you are seeking it, is workable and realistically achievable for the defendant to do in the timescale sought. It's all very well sticking in an application for the defendant to comply with its statutory obligations, but if it's practically unworkable, then that's likely to be met with a fairly dull, dim view from the court. So that is the end. And I'm just under my 15 minutes allotted time, which is excellent. So I will hand you back to Mathew. Thank you very much.
Well, thank you very much indeed, Mathew, for that illuminating discussion of those two topics. I was taken back to a mini pupillage 20 years ago, where in the Court of Appeal, the first complaint made of many at the beginning of the hearing was about the quality of the bundles. In that hearing, of course, it was poor photocopying. But one can see if you don't comply with bundle guidance that's very prescriptive and specific for good reason now, that those complaints may be made in a slightly different way. Thank you very much indeed again, and we'll now turn to Alistair Covley, who is going to conclude this afternoon's talk. Alice.
So thank you. I'm going to just talk very briefly about venue, and then I will talk about the judicial review reforms that are being widely discussed on Twitter and elsewhere. So firstly, Practice Direction 54C. This is not new, in effect. There is one small part of it that it is new, but in effect, the main change is the letter. So this is Practice Direction 54D, now becoming 54C. So the venue requirements, just to remind you, you may remember that the admin court is organised by geographical region. So if you have a case where the need to file it would be in the Midland Circuit, you would have to file in Birmingham, Western Circuit, Cardiff, Northeastern Circuit, Leeds, Northern Circuit would be Manchester. And this is because the admin court applies the principle that where a claim has a specific connection to a region, so that might be because of its subject matter, the location of the claimant or the defendant, or otherwise, and there are a list of factors to consider in the practice direction. The case should, if at all possible, be administered and determined in that region. So that also means filed as well in that region. And in specific terms, this means making sure that you look at the question of where the claim is most closely connected. So that would be apart from accepted claims. Now I'll come back to accepted claims that have to be determined in London only. But for the most part, you are looking at the following factors. So this is the typical list that you might be familiar with from previous Practice Direction 54D, but the new part, which is not really that new, it just sort of widens what is meant by the interest that the proceedings might have in that area, is under D here. So the extent and nature of any public interest that the proceedings be heard in any particular locality. So previously in 54D that said media interest, and now that says public interest. But it is a familiar list, I think, with what you'll be looking at to determine where it is in all the circumstances that you would consider the claim has the closest connection. There are the accepted claims, so those are generally terrorist-related proceedings, POCA or Process of Crime Act cases, confiscation proceedings, extradition. Proceedings that must be heard by a divisional court must also be heard in London, and also discipline of solicitor cases as well. So it is really those that only need to be you need to be careful about in terms of where it would be filed and administered. But for others, it's really about looking at this list and determining where it is considered to be most suitable. So that's quite quick, I think, in terms of 54C. The reforms, however, are a lot more interesting, in my view, than 54C. So the government's response followed the publication of the Independent Review of Administrative Law. This was the IRAL, and that was chaired by Lord Faulks QC. There was some concern from IRAL that some had thought at the time provided for the review itself had not been sufficient, and the terms of it didn't allow for sufficiently wide consideration. So there was some concern from, for example, the Law Commission about that, about it. And we will provide links to the IRAL consultation, the IRAL review after this talk. And then the government after this published a further narrowly focused consultation. This included proposals that they set out in their own published response to IRAL. That was in part based on IRAL's recommendations, but also including new matters appearing in the government's response. So that's in section 5 of that. So the government also made further suggestions of its own that went beyond the suggestions that were looked at in the IRAL review. The Lord Chancellor said that those further suggestions were the most pressing issues in his foreword to the response. There was this consultation, as I say, that lasted from the 18th of March to 29th of April, Many of those consultation responses have been widely circulated, and there's one that I've given a link to from ALBA, which is particularly worth a read, I would say. And a number of those responses themselves criticised the nature of the consultation, saying that it was too short and unclear, confused and confusing. Those are some of the perspectives on it. But in short, there has now been the announcement of a judicial review bill per the Queen's speech in May. So what I also wanted to just highlight at this point is that many have picked up on the government's response to IRAL and the particular wording of the Lord Chancellor in the foreword, which was repeated in the press release at the time, where it said the panel's analysis identified a growing tendency for the courts in judicial review cases to edge away from a strictly supervisory jurisdiction, becoming more willing to review the merits of the decisions themselves, instead of the way in which those decisions were made. The reasoning of decision makers has been replaced, in essence, with that of the court. And so I really do recommend reading the ALBA response in respect of that. In short, they highlight a number of examples where perhaps it could be argued that that anxiety is misplaced. There's a case law that many will be familiar of, but particularly in Begum and in the McConnell case. That was the case involving the transgender father looking for a name on the birth certificate, are two examples of where the court looked and warned against being, I suppose, nervous about interfering with the executive at that respect. But in the time that we've got, I think I have a couple of minutes, so I'm going to go through the key headline points. The Queen's speech did highlight in particular suspended quashing orders, so it's likely that those will be pressed through. So I'll go through those, and I'll also look at the question of promptly, because actually I think that has some quite interesting practical implications for practitioners. So there's a long list of things that are being considered by the government. So the first is legislating to reverse the effect of the Supreme Court decision in Cart, and to reaffirm that decisions of the upper tribunal to refuse permission to appeal are not subject to the supervisory jurisdiction of the High Court. There's also, as I said, legislating for the introduction of suspended quashing orders, as SQOs. There are some changes to procedure being considered. So we've already had a whole swathe, of course, of procedural changes, as you've just been listening to for the last 45 minutes. But there are further small, significant partly, but other smaller things that are still being considered. So that's the requirement for a claim to be issued promptly, you may have read about, but also retaining that 3-month time limit. There's also talk of some guidance for interveners that may follow, given the practice direction changes in that respect, and also an extra step in the procedure to make a reply mandatory. Many do already do that, but that would be then filed within 7 days of receipt of the Acknowledgement of Service. That was the core part of what was looked at in the review. And the government is also looking at further reforms. That includes legislating to clarify the effect of statutory ouster clauses, legislating to introduce remedies which are of prospective effect only, to be used by the courts on a discretionary basis. There's also legislating that for challenges of statutory instruments, there is a presumption or a mandatory requirement for any remedy to be prospective only. There's also legislating for suspended quashing orders to be presumed or required. So rather than one of the range of remedies, actually the primary presumed remedy. There's also legislating on the principles which lead to a decision being a nullity by operation of law, and finally other smaller procedural reforms. So I'm just going to briefly, as I said, just go through the quashing order point. The reason why the panel is recommending that Parliament looks at suspended quashing orders is because of, they say, wanting to provide a remedy of suspension to alleviate the bluntness of a quashing order. That's their words. And they say that this is because quashing orders can sometimes have a disproportionate effect compared to the impact of the procedural error being reviewed. So this would then be a new discretionary remedy available to the court, and would be an opportunity for the public body in question to remedy any defects identified by the court, with the SQO automatically taking effect after a certain period of time if the specified conditions are not met. And there are some mixed views about the efficacy and utility of these SQOs. And they would also, I think, highlight that there are several examples where courts already recognising where a quashing order might be disproportionate, and that's why for example, a declaration would be able to get to the issue at hand. So the case of Blundell, really recent case, this year actually, which was a challenge to the government's policy for making deductions from claimants' universal credit to pay fines under the criminal law. And in that case, the judge held that aspects of the government policy were unlawful, but said, I do not propose to quash the policy. There are many parts of it that are good in law and untouched by this judgment. Severance of the good parts from the bad may not be easy. I'm minded to grant a declaration in a form which I hope would be agreed between the parties. And the court did grant that declaration, and then the policy was amended forthwith. So there are a number of groups that say, well, the power of a declaration is that is enough, and that others say that the benefits of SQOs are materially overstated. I looked at a number of different responses, but Liberty has an interesting response on this, as well as the Bar Council. The Bar Council has pointed out that the proposals for suspended quashing orders envisages leaving the old law in place in the interval between the judgment and the time the quashing order comes into force. So then what is the decision maker to do when he needs to decide an individual case in the gap? And so if, for example, there's a decision that the law is not X but Y and issues a suspended quashing order, the logic, and this is the Bar Council's position, the logic of the government response is that the decision maker applies law X despite the existence of a judgment saying the law is Y, and they say that this is at the least extremely odd. So there is the question about the practical ramifications of SQOs. And also some are concerned that it might be difficult to challenge, for example, local authority decisions, particularly in social care and in education cases. In balance, I have seen some positive noises from planning. Some say that it might provide a legislation-backed method to correct errors and prevent the wholesale quashing of planning permission, which might have taken many months to obtain through the planning process. I have seen some positive noises in that respect. So it'll be very, very interesting to see if that is going to be taken forward. I've got one more minute, so I'm just going to talk about promptness. The government's also looking at the promptness requirement as well. So this is, as you all know, the 3 months, but in any event, promptly requirements. It's actually been removed in Northern Ireland in 2018, and Scotland followed suit. So there's some argument that there should be some parity across the 12 nations. In my experience, and I'd like to speak to others about it here, where claims are filed within 3 months, defendants don't generally raise arguments that there's been a failure to file promptly and that then the court will dismiss it on those grounds alone. And there can be some real utility in saying that 3 months actually does mean 3 months to allow for attempts to resolve the issues or settle the claim rather than trying to rush to judicial review. So there's some arguments that it can help with allowing the pre-action protocol to be used properly. But there are a number of examples where it might, of course, still matter. So you may remember the Fawcett Society challenge in 2010 to the budget, where that claim was brought 5 weeks after the budget, and actually after some measures had been passed into law. and permission was refused on the basis that the challenge had not been brought promptly. So you can see there are plenty of good examples where promptness will matter. And I also think that in education cases, there will be obvious allocation of school places matters where it would be vital for claims to be brought promptly, because it would matter for the child, the parent and the school to know the numbers in the classroom because of the strict rules on numbers. There's a number of cases, Rochdale, Beckett and Hammersmith, about that point. And I think also in terms of cases involving school reorganisation and closures, again, that there would be obvious arguments for promptness being a key feature. So I personally see the merit in removing the promptness as the kind of headline requirement, but I don't see it going away as a principle altogether. So we'll have to see what happens with that one. But I think that's all the time that I can give to the reforms. As I said, there's plenty of information online about the various bodies' responses to it, and I am told that a response to the government's consultation exercise is due to be published by summer 2021. So I suspect we'll be doing another seminar at that point on it. Okay, thank you.
Thank you very much indeed, Alice. It's 4 o'clock, so we'll just briefly have a couple of questions. Those of you who've asked questions which aren't answered, we'll endeavour to get back to you directly. Can I just deal, first of all, with a timing point? Caroline, one question on 54A and indeed generally, are there transitional provisions for these new practice directions, or do they just come in as of yesterday?
The short answer to that is that there are no transitional provisions. So for those of you who spent your bank holidays getting to grips with the changes in the practice directions, well done, because you know exactly what you need to do as of this very moment. In reality, there may be a little bit of leeway, but I wouldn't assume that leeway from the administrative court will be terribly generous. So the rules are in force as of now, and comply with them or risk the consequences. Thank you.
We've had a question on urgent interim applications. Will these be accepted for in the education field for provision for education for a child out of school or for SEN provision, special educational needs? Who'd like to take that?
So I think, annoyingly, I think the answer will be, it depends. So it will be contingent on whether it's actually an emergency. So I spoke about cases involving children's school places, but I think the courts will generally accept that the education of children is in principle very important, but I think it has to be looked at in a wider context. So there's no one size fits all answer to that question, I think. There will be some good examples of where it would be justified though.
Thank you very much, Alice. Mathew, one question prompted by your talk. When you're preparing a hearing bundle for a final hearing in a judicial review, obviously you've got the claimant's bundle file with the claim form, for example, and there may be cross-referencing and to pagination within that bundle in the claimant's grounds and perhaps even in the defendant's grounds. When you then have to create a final hearing bundle, you may end up with a situation where the automated PDF numbering has to be changed because of the insertion of documents into the PDF. Do you think the court would accept the original permission bundle plus a supplementary bundle containing the new documents, or will the references, page references, cross-references to the new PDF numbering need to be changed throughout with a single PDF?
Well, thanks for that question. My view, I think, is probably the unpopular view, which is I think that in principle everything needs to be changed if you follow the strict words of the bundle guidance. However, that being said, the reality is these are new guidelines. There are obviously going to be some teething problems, and I think the best port of call is probably to call up the admin court office. They have obviously their admin court lawyers who should be able to deal, I would have thought, quite promptly with these kind of queries. So in default, yes, I think you need to repaginate everything. sitting on the fence, give the ACO office a call.
Thank you very much, Matthew. And finally, one final question. We've been asked, are there any changes for Aarhus applications, environmental claims and filing requirements, please? I'm not aware of any, whether in the practice directions or the government's proposals. Alice, are you aware of any changes of that nature? I think we'll, no, I was saying no. I think if there are any, then we'll certainly get back to the questioner on that, but I'm not aware of any in these proposals. Well, I'm afraid that's all the questions we have time for, and apologies for slightly overrunning. It only remains for me to thank all of you for attending this afternoon, and to thank our three speakers for their insights into the changes in the law, both actual and anticipated. You should, as I've said, receive the PowerPoint slides and links in due course, and thank you all very much for attending. Thank you very much.